And as a reminder, we're not attorneys, and the information provided is meant as educational and operational advice. For legal advice, please contact your legal counsel. Patty Widget has more than 22 years of experience as a regional property manager. Patty teaches a wide range of classes on property management topics, such she is a keynote speaker and has published numerous articles for apartment associations. Patty is a repeat guest speaker at UCLA. She also holds various certifications in the industry related to her field, such as a CA licensed real estate broker, CCRM, lead-based paint certified renovator from the NPA, and the fair housing and more. So I'm going to turn over to Patty, and she's going to get started. Okay.
Hello, good morning, everybody. Welcome to Fair Housing. I have a lot of people tell me fair housing isn't fair. You're right, it's not, it's equal. So there's a difference there. We got to keep that balance right, okay? Fair housing is definitely something we want to consistently be in compliance with, and we don't want anybody to feel that they've been discriminated against or segregated in any kind of way. Being in this industry so long, I stopped long ago seeing colors of people's skin tone or their ethnic background, and I just see humans. So my theory is you're either a good human or you're not a good human. There's no wiggle room there. So if you start looking at things from a different perspective, it actually does help you pull all that together. So today we're going to talk about fair housing. I am going to go a little bit into fair housing laws, regulations, some of the protected classes that we have in California because it's insane, okay? And just trying to give you guys some tips and tricks as we go along through the process. Again, if you have questions, please stop me, ask me, let's talk about it. Let's talk about it while I'm fresh on the subject so that I don't get bamboozled. All right, fair housing. The Fair Housing Act was the Civil Rights Act of 1968, and it was amended in 1988. So the FHA prohibits discrimination in the sale, rental, financing, or advertising of housing based on race, color, religion, sex, national origin, familial status, and disability. Simply said, federally, we have 1, 2, 3, 4, 5, 6, 7 different classes. It's race, color, religion, sex, national origin, familial status, disability. California, we have the most, believe it or not. There's like 26 protected classes. Not only does it have the ones I just named, they also do sex, gender identity, gender expression, disability, ancestry, age, sexual orientation, marital status, source of income, genetic information, arbitrary factors, citizenship, immigration status, primary language, and also military status. So we have a lot of things that are protecting tenants, home buyers from being discriminated against. Again, if you just think of everybody as human, they're either a good human or they're not a good human. It kind of takes all of that out of the equation. So today I want to talk about some of the discrimination acts and how they can happen and how easily they happen. And I'm going to give you guys a couple of examples right out of the gate regarding familial status, because this is a key one for me and I see it all the time and I'm like, no, don't do that, please. It could cost you a lot of money. Things you need to know in a fair housing issue is they can sue you for your own personal assets too. So not only can they come after the company, the owner of the building, they can also come after you. You are the licensed professional in the industry. You need to know where you stand with fair housing and make sure that you're following those rules. Arbitrary factors is definitely on the rise, but the one that I see the most is familial status. And I know we don't mean to do it, but I'm gonna go through the little motions here and you guys see if you can follow me. So I want to rent, and I'm the landlord, okay? I want to rent out my studios, okay? So I want to limit it because it's only 600 square feet. They're studio apartments and I have 6 of them, okay? And I only want 1 occupant per unit because it's only 600 square feet. So I put single occupants only. Are we talking about 1 single person, or are we talking about somebody that's not married and doesn't have kids? You guys with me? In the event that you need to advertise housing for one occupant, please say occupancy limit is one person's. One person. Don't use the word single in your advertising. It can be deemed as discrimination against marital status. Does that make sense to all of you guys? I mean, basically, when you put as one single person only, it sounds like you're only renting to single people and not anybody that's married or has children. I get that you're only one person, but you have to fall in line with fair housing guidelines. So that's a very common one that I see quite a bit. And we'll go down my list of pet peeves of other issues that I see, because another one that I see is regarding disability, and it's super easy to do. We've all done it, but I kind of want to retrain your brains so that you don't do it going forward, okay? Familial discrimination is one of the more common forms of discrimination. It's based on familial status. Both federal and state laws say that it's unlawful to discriminate against families with children. Familial discrimination occurs when individuals with children are treated differently than others. Whenever there's a rule or a policy change about a protected class, it's discriminatory. Charging a higher security deposit for families or forcing families to live on the first floor are examples of unlawful discrimination based on familial status. There are two other instances where familial discrimination is often seen, and it is occupancy standard and the house or the pool rules, okay? One of the things that we always utilize, and I don't want you to use it, is children. Children are a protected class. So anything that you say in regards to children, put in writing, etc., could be considered discrimination unless it is the state law, which applies to swimming pools. And it says all persons under the age of 14 must be accompanied by an adult. All children, I believe is what it says, under the age of 14 must be accompanied by an adult when using the pool. That is the only time the word children should ever show up. There's still occupants in your property, okay? There's still residents there. So address them as such. If you have the kids throwing rocks in the pool, okay, you may want to write a letter to the tenant stating that occupants from within your unit were seen throwing rocks in the pool. That way it's not a child thing, a children thing. You got to be really careful what you put in print and extremely careful what comes out of our mouths. So we want to be careful with that. The other thing was the occupancy standard, like I was explaining to you when you use single person. It sounds extremely discriminatory. Are you saying one person, or are you saying only single people that aren't involved can live here? So that's where that becomes a little tricky. You want to make sure you're very careful with your wording. When in doubt, always have someone double check for you, because this could be extremely costly, okay? And I mean extremely. It is unlawful for a landlord or an owner to limit the use of facilities or take privileges away from a protected class. So when you say things like no playing in the common area, is that discriminatory? Absolutely. You have to be careful what you put into print regarding playing and children, okay? Can you say no loitering in the common area? Absolutely. I didn't identify a class. I didn't segregate, discriminate, or any of those things. So you can simply just put there will be no loitering in the common area. You can't use the word playing, and you got to be really careful. And I'll give you guys some examples of some lawsuits I've seen come across my desk, because I also worked at a law firm for 4 years, just so I had a better understanding of how that worked. And the language they speak, because sometimes what they talk about is foreign to us. You know, they use words, our attorneys use words like your interrogatories, and you're looking at them going, okay, what is that? Well, that's kind of like your chain of events. Well, why didn't they just say it that way? Because they have their own language. So getting back to discriminating and things where we can find trouble is when you say things like no kids in the pool, no kids on the grass, if it's for a safety purpose, the rule isn't discriminatory. And I want you to take that with a grain of salt, because safety would be with that pool rule, okay? And that's the only place I want you to ever use the word children, child, minor, etc. They're still occupants within that unit. So address them as such. It helps take away a lot of the scary parts, okay? One of the things that I see quite a bit has to do with walking and discriminatory factors. So when you use the word walk, it could be extremely, like I see walk on something and I'm like, red flag, red flag. Don't use the word walk. We put it in a lot of places. Walking distance, walk-in closets. That's discrimination against someone that can't walk, that's in a wheelchair. So when you put walking distance to the mall, you're putting in writing discriminatory factors in your advertising. So be careful. Stop using the word walk. Stop using the word children or child or playing, because they all go together, okay? You can use spacious, oversized closets, close proximity to the mall, yada, yada. Don't use the word walk. It can go bad very quickly, okay? When you're setting terms and conditions in your rental standards that charge on a per person basis formula, charging extra deposits for presumed wear and tear, restricting use of facilities against families with children, these are all forms of discrimination. So if you charge a family with 4 young children an extra security deposit because the landlord feels that the children could potentially damage the property, then that's discrimination. Okay, it happens that easy, that quick, okay? So be careful with that. Occupancy standards, I'm gonna get back into this in a little more detail. Occupancy standards can violate fair housing laws if they adversely impact families with children. The California Department of Fair Employment and Fair Housing has set forth a guideline of 2 persons per bedroom plus 1 for occupancy standards. A policy that is more restrictive than that guideline could be considered discriminatory. Please also know that that's not the law, it's a guideline. The law says, don't shoot me, okay, that we can have 9 persons for every 690 square feet. That's California Building and Safety, right? Can you imagine if we stuck 9 people in 690 square feet? We'd have dressers over the windows. They'd be blocking exits in the event of a fire. I mean, it just goes on and on and on. So an attorney taught me once that if you want to limit your 2 plus 1, it needs to be in 2 places for it to be enforceable. It needs to be, number 1, on your criteria that you only allow 2 persons plus 1, 2 people per bedroom plus 1 as your occupancy limit. And it needs to also be in your rental contract. So for you to enforce an occupancy limit, it has to be in 2 places, on your criteria and also in your actual lease contract. And definitely talk to your attorney before you make any changes there to make sure that you're not discriminating when you put that in writing. A landlord could get in a lot of trouble in the event that they advertised seniors only for senior housing if it's not senior housing in the bylaws. I recently saw something happen. A landlord decided he was going to build a senior community. He made it all seniors. He never got it permitted that way. So he couldn't do that. So he got quite a bit of slack and a few discrimination cases against that. There's a lot of times where we don't mean to do something, but it just kind of evolves that way, and we have to stop and think about it. Wait, could this be considered discrimination? We need to be very careful that we're not discriminating right out of the gate, as it can cause a lot of trouble. And there are people out there that have nothing better to do with their lives but make yours a nightmare. So we want to be careful that we're not feeding them improper information at the same time. When you're renting, and some people do this without even thinking about it, when you start segregating and saying, okay, we have families in this area of the community, and over in this area of the community, we have seniors, and in that area of the community, we keep the single occupants that are loud, noisy all night long. You're basically segregating. That's discrimination. If somebody wants to move in to that particular unit and it's available and they meet your criteria, then they get to move in there. That's how that works. We don't want to steer someone towards a direction so it would be more comfortable on the community. We want to make sure that we're not doing anything that's causing segregation. I mean, it's easy to do, believe it or not. If you're taking a senior citizen on a tour of a property and they're having difficulty with the stairs and that's the unit, you can offer to show them one that doesn't have stairs, but I wouldn't address the fact that the stairs are the issue. Let them tell you that that's a problem. There's certain things you can do when you have people that are having a little bit of difficulty going up and down the stairs, and I always point out to them, oh man, I would hate to have to lug my groceries up these every week. Kind of plant that seed of, hey, this might not be ideal for you if you really start thinking about it, but I do have one that's on the ground floor. I can show you a unit with no stairs if you prefer that. There's nothing wrong with you saying something along those lines because you're not discriminating against them. You're basically asking a question whether or not they prefer stairs. You can't rent to people that have children because your pool's not fenced in. That would also be considered discrimination. So I saw that happen recently, so just wanted to throw that one in there as well. Not renting to people with children because there's elderly people in the complex that could get hurt or annoyed by children running around and screaming. Can't do that either unless you're a senior community and it's in your bylaws and in your zoning. You really can't do that. So we want to be really careful not to do those things. They're real super simple to do. Steering is another form of discrimination. It's unlawful to discourage an individual from inspecting or renting a unit because of their protected class. It's also unlawful to assign an individual to a certain section or a floor of the property because of the individual's protected class. I just kind of gave you that whole scenario of children in this area, seniors in this area, partiers in that area, yada, yada, yada. It's easy to do, you guys. It's real easy to do. So you want to be careful that you're not doing that, okay? You want everything diverse. We don't place people in units. We place people when units become available, okay? That's another little trick of mine. Examples of steering would be segregating the protected class from one side of the building, assigning older individuals to the first floor, assigning individuals with children to the first floor only so that there's not a noise disruption. That's all steering and we can't do that. It's bad. Sexual discrimination is the simplest form. It occurs when a landlord, a property manager treats men and women differently. Additionally, sex discrimination occurs when a housing provider provides different terms and conditions based on sex or denies a housing application, a dwelling, or evicts a person because of their sex, including gender, male, female, gender identity, gender expression, includes but not limited to pregnancy, childbirth, conditions related to pregnancy or childbirth. So if you're telling your tenant they can't breastfeed in the pool area, that would be discriminatory, okay? I think that's a good one, actually. Requiring your female tenants to wear swim caps for their hair, also discriminatory. So somebody needs to push mute because we can hear your conversation. Getting into sexual harassment, it takes place in all stages of tenancies in many forms. California law defines sexual harassment as verbal harassment, physical harassment, visual harassment, sexual favors. Some examples of sexual harassment include, but are not limited to, refusing to rent to a person who resists the landlord's sexual advances. Okay, I'll try not to giggle too hard. Require sexual favors from tenants, retaliate against a tenant who has registered such advances, name calling, belittling, touching, requiring a person to wear sexually suggestive clothing, displaying sexual pictures, staring at a person's anatomy, continued request for dates, not like in a dinner date type of scenario, and termination of tenancy if requests for sexual favors are not given. Those are all forms of sexual discrimination, sexual harassment. Domestic violence. We have a lot of laws in regards to domestic violence, so I'm going to throw a new one at you that happened recently. Domestic violence is a violent confrontation between a family member or household members involving physical harm, sexual assault, or fear of physical harm. Family or household members include spouses, formal spouses, those in a dating relationship, formally or not formally, adults related by blood marriage, and those who have biological or legal parent-child relationship. It is unlawful for an owner or an agent to discriminate against an individual that is a victim of domestic violence. With that being said, please take note. They took that a step further. So now a tenant can get out of their lease contract with a 14-day notice by giving you in writing stating that they're a victim of domestic violence. They can break their lease term, they can move out immediately. If they're a victim of domestic violence, we have no choice but to release them of their lease contract with just a 14-day notice, just so everybody's aware. And a third party can write a letter also, just so that you're also aware. And I'll give you an example to that. This one recently happened within the past 2 years. Is if I'm a victim of domestic violence and I'm getting beat up every night, and I confide everything in my best friend. Okay, my best friend is Sam. And Sam writes a letter and says, hey, Patty's a victim of domestic violence. She gets, she's going through all of this. So you need to allow her, she's going to leave. You need to allow her to get out of her lease. That is something that you are most likely going to have to accept as a letter of termination if you have a third party telling you about the abuse that's going on or the violence that's going on. I know it kind of is a loophole and we get frustrated. What do you mean? They can just have their friend write a note and be out of their contract in 14 days. I get it. But at the same time, I also would really want to do something for my friend to help them if they were the victim of that. So remember, there's always two sides to every story, and we sometimes only see the one that affects us the most. Keep that thought, okay? Sometimes we think of the scenario that just affects us the most and not what's happening to that other person. Let's see. Immigration status. Persons who have not been born in the United States or who are perceived to be immigrants, we can't require a tenant to provide us with a social security number. Asking the tenant or applicant if they have a green card could be discrimination, absolutely. And asking for a birth certificate, same thing. So we cannot discriminate against immigrational status. And it also kind of makes me wonder sometimes. I mean, come on, I am blonde. I do try to think outside of the box. But my theory went like this. Trump wants to build a wall, right? why not just give us the power, us, property managers, the power to discriminate against immigrational status, and we would build the wall for him without spending all that money. But what do I know? I'm just blunt. Kind of made sense to me. So immigrational status would be people who were not born in the United States or perceived to be immigrants. Primary language is also a form of discrimination. So persons whose primary language is not English. So if you are refusing to rent to someone because they don't speak our language, English, that would be considered discrimination, just so you know. If you give them different treatment, that could be considered discrimination. Evicting them because their primary language is something other than English, or not allowing non-English speaking tenants to speak their primary language, or having an English only policy in the community. Can't do any of those. Citizenship. Any person who is not a citizen or national of the United States. This would be inquiries about the applicant's place of birth, requiring a passport or a green card or other documentation to show where they were born, requiring proof of the tenant's legal immigration status into the US. All, again, forms of discrimination based on citizenship. Medical condition, this happens more than we know. Any health impairment related to or associated with diagnosis of cancer, or a record of history of cancer or genetic characteristics. Examples: not renting to a person who's recovering from cancer treatment, charging a double deposit for people that are going through cancer treatments, things like that. We need to be mindful of that and make sure that we're not discriminating in that direction either. Religion. Religion includes all aspects of religious belief, observance, and practice. Additionally, protection includes religious dress and grooming practices. So denying somebody housing because of specific attire related to their religious beliefs, prohibiting non-Catholics, Muslims, Buddhists, things like that from participating in their religion. Implementing dress codes for residents. As soon as I saw that, I was like, are you kidding me? But apparently somebody's done it before. That's why they're telling us we can't. And providing a preference of persons of a specific religious group. In other words, if you have a property that's close to the Buddhist temple, and I'm just giving an example, we don't want to put close proximity to the Buddhist temple. That could imply that we're only looking for someone that's a Buddhist, and we're now discriminating against their religion. So I want to be careful about that. I don't ever mention any kinds of churches or places of worship in my advertising. And the reason I say advertising is that's usually where this picks up right away, is in the advertising. So you don't want to put close to church, close to this, close to that. Close proximity to, remember, don't use the word walk. Disability. Discrimination based on an individual's disability is protected under the FHA. The federal law states that disabled residents are entitled to have reasonable accommodations, okay? When such accommodations or modifications may be necessary to afford a person an equal opportunity to use and enjoy that dwelling. Example, let's say that they want grab rails installed in the bathroom, okay? Do we have to allow it? Absolutely. They need to fill out a request for reasonable modifications. There's a difference between an accommodation and a modification, and I'll talk about that so that we're all on the same page, okay? Accommodation is you changing the rules. You with me? A modification is you changing the property. Okay, so if someone wants grab rails installed in the bathroom, that would be a request for modifications. Then, most likely that can be done at the tenant's expense, and you can charge to put it back when they move out. And I'll give you another example. Let's say they want the countertops lowered so that they can reach them better. We don't usually see this in rental properties, but if they asked, you would have to allow them to do that at their expense and then put it back when they vacated. Same thing with widening the door frames or getting in and out of the restroom sometimes can be difficult if you're wheelchair bound or something along those lines. So difference between an accommodation and a modification: accommodation changes the rule, modification changes the property. That would install grab bars, flashing strobes for the smoke detectors rather than just the sound if they're hard of hearing. That's another example of a modification to the property. Handicap ramps, things of that nature. An accommodation is changing the rules. And this is where we get into emotional support animals and things like that. Whenever someone wants something changed, okay, based on a disability, whether it be a modification of the property or an accommodation of their rules and regulations, you need to have documentation of that to prove to the Department of Fair Housing in the event of a lawsuit, okay, that they requested something and you changed the rules for them based on a disability, not on anything else, but just to make them more comfortable. That's why you did that. Otherwise, why didn't you change the rules for everybody else in the community? So it's a paper trail you want. It's actually a form. So they need to fill out their request for reasonable accommodations or their request for reasonable modifications. Okay, then you go through this process of approving and allowing that to move forward. So make sure you document this kind of stuff. I'll give you an example. Girl, on-site manager in a huge apartment community has this little old man. He's a sweetheart. She loves him. He has trouble walking, okay? And I mean, this man has trouble. So she gets his mail for him every day and takes it to his unit. What a sweetheart, right? No, that's discrimination because she didn't go get everybody else's mail and take it to their door for them. That makes her discriminating against everyone else in the community and catering to this one person. See the problem? It happens that easy. If you do for one, you have to do for all. Unless you have a request for a reasonable accommodation or a reasonable modification. Okay, I get a lot of questions regarding service animals just because it's so challenging for us. Here's my theory. Stop looking at them as pets because they're not, okay? To protect you completely, you either have an animal or a pet, okay? When it comes to pets, there are no rules. You can pretty much do whatever you want. Seriously, there's no laws regarding pets. You can say you only take pink poodles that are papered, and that's it as far as your pets go. You can set the rules for pets. When it comes to animals, we're talking about emotional support animals, therapy animals, guide dogs of America, service animals. I mean, I could go down the list of all the different names they have. So animals, pets. When it comes to animals, what you can do is extremely restrictive. Have them fill out a request for reasonable accommodations so that you have that paperwork in there of why you let this person have an animal, but you didn't let everybody else if it's a non-pet community, okay? They also need to have documentation from someone stating that they have a need. And I'll give you an example, and please don't shoot the messenger because this happened rather recently in the past 2 years, where any professional that is aware of their condition and their need can write the note. Example, you manage investment property for a living, right? I'm going to assume that you get woke up in the middle of the night trying to remember if you did something properly. That's called work-related stress. So as a real estate broker in the state of California, I'm aware of your condition and your need. Could I write you the note? I could. See how that worked? Okay, so stop thinking that a doctor has to write that note. It could be a life coach, a therapist, it could be their priest, it could be their preacher. It must be a professional in the industry, aware of the condition and aware of the need. That person can write the note. So be careful with that one, because we're always saying doctor's note, doctor's note. It doesn't have to be a doctor, just so you're aware. Okay, let me get back to disability. If you have, and I'll give you more examples because I try to really help you guys with examples. Let's say a tenant gets Social Security disability and their check comes in on the 14th of every month. So now they want to change their due date of their rent to the 15th of the month. That would be a request for reasonable accommodations. Okay. They're going to have to fill out a paperwork stating what they're requesting and why. And as simple as I said, that is as simple as they could write that out. That easy. Do we have to do that? Absolutely. Absolutely. Okay. So there's another form of a modification versus an accommodation and knowing the difference. Does anybody have any questions about that? Because I just want to make sure we're square between accommodations and modifications. And remember, anytime you make an exception or a special accommodation for somebody, you want to have the paper trail behind you for fair housing, so they could say, why did you change the rules for this person and not for all the rest of these people? That's where you can kind of get in some trouble, if that makes sense to you. So you want to make sure you have that paper trail in the file stating, yes, they have an assistive animal and that's why I changed it. And here's the paperwork proving that they required a request for accommodations or modifications accordingly. And it's up to you. And here's I'm going to give an example. Okay, and please hear me. I know that we could charge the tenant for putting in grab bars and charge them back and all of that, but my theory is real simple. If they have issues getting in and out of the tub, I don't want to slip and fall. So I may ask the landlord to pay for that they're requesting, just to keep that balance right between landlord-tenant relationship, because it's really important that we do keep those balances right. Otherwise, we have tenants that do this all day long. So keeping that balance right is something else that we can do. So if it's reasonable, and I'm saying grab bars, what does it cost? $100 to install those? If that might be something we ask the landlord to accommodate, just to keep that landlord-tenant balance right and keep everybody happy. Okay, just a thought. So we don't always have to make them pay, but remember, if you do for one, you have to do for other. So if now 3 people want grab bars put in and you didn't charge the last guy, guess what? You're not charging the rest of them either. So keep that in mind. If you do for one, you have to do for the rest. Keep things even, Steven, across the board. If nobody has any questions about modifications versus accommodations, I'll go ahead and move on, because there's a whole process of verifying that request, making sure that it's legitimate. I see a chat question came through. What if 2 residents are on the lease? One of the residents puts in writing domestic violence and leaves, and the other resident stays. There is property damage. Can you evict the remaining resident? Well, it depends. And let me answer this carefully. You have 2 residents on the lease. One of them puts in writing that they're domestic violence and they leave. They're still responsible for the property for 14 days. If the other resident stays, then they're staying in the property and that relationship's still going. So when they vacate, the residents that stayed, you would take that out of their security deposit. If they're damaging the property, could you evict the remaining tenant for property damage? Most likely, but that's something that you're going to have to talk to your legal counsel about. Okay, so yes, most likely. I'm choosing my words carefully, but definitely something you want to talk to your legal counsel about. I hope that answered your question. And if it didn't, holler at me. We'll dig deep down in there. Okay, so. Oh, wait, hold on, I get another one. Is illustrating pedestrian friendly a better option than a walkable area? Yep, pedestrian friendly, perfect. We don't want to use the word walk. We don't want to use the word playing, and we don't want to use the word children, or anything along those lines, except in the California state law. That's my rules, okay? I try to be very careful, and then I'm going to do you guys all a big solid, okay? I learned something at the law firm, and it helped me considerably, okay? They taught me, Patty, if you don't write in absolutes and if you don't talk in absolutes, then you absolutely can't give the wrong answer.
Don't write?
Bing! Did that all click? Okay. So if you use words like could, should, might, most likely, you're not giving a definite answer. If you're not giving a definite answer, you're definitely not giving the wrong answer. Got it? Use words like could, should, may, most likely. Okay, you guys with me? When you write and you put it in writing, and I'll give you an example. We have government order to shelter in place issued by our Governor Newsom, blah, 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 blah. You could get arrested if you are caught congregating in groups more than 10, right? Sound threatening? No. You will be arrested if you're caught in congregating in groups more than 10. Threatening? Absolutely. If you don't talk in absolutes, then you absolutely can't give the wrong answer. Okay, you guys with me? Everybody get that? Anybody have any questions? So when you're writing, remember this. If you don't write in absolutes, you don't sound threatening in your letter. You could, most likely, it might, it may. See how that worked? So just something else to put in your arsenal, you guys. If you don't talk in absolutes, you absolutely can't give the wrong answer. If you don't write in absolutes, you don't sound threatening. Just saying. Yes, that's right out of my tricks. All right, so we talked about reasonable accommodations and reasonable modifications. Want to talk a little bit about the interactive process, and you'll hear attorneys talk about that. Just so you guys know, that's a conversation you have with your tenant. Oh, I didn't know that you needed flashing strobes. I was unaware that you were hard of hearing. This is called the interactive process. When you have that conversation with your tenant about whatever the issue is, know that that is called the interactive process. That is you communicating with them. Some of the things that you could deny a request for reasonable modifications, meaning you're changing the property, would be an undue financial burden on the owner, okay? Example, if the cost of the requested accommodation, the financial resources of the provider, if it's gonna cause undue financial burden to the landlord, and this has to be done on a case-by-case basis on those modifications, it could actually be denied. I'm gonna let you know right now that that undue financial burden starts at about $10,000. So if it's going to cost the landlord more than $10,000, I would talk to your legal counsel and see what they suggest that you do. If it's less than $10,000, chances are the courts are going to make the landlord do it. Just saying, that seems to be the number. It's about $10,000. So be aware of that. Talked a little bit about assistive animals. Does anybody have any questions about them? Please pipe up. Service animal, emotional support animal, companion animal, assistant animal. The reality is it could be anything. It could be a dog, a cat, a bird, a fish, a reptile, a horse, a pony. You have municipalities, AKA your cities, your counties, your state, etc., that has restrictions. So I'm going to give you an example. Let's say that you're in the middle of the city of Los Angeles and your tenant has an emotional support goat, okay? Goats are considered livestock and may not be allowed in the city that you're in. So if the city has a restriction, remember this, you guys, we sit about right here on the totem pole. The city sits above us, the county sits above them, the state sits above them. If anybody above you has a rule about that particular animal, that is your loophole to maneuver of, I'm sorry, the city does not allow livestock within city limits. So that's something you're gonna have to take up with the city. It helps if somebody has a Bengal tiger, you know, you may wanna call Fish and Game or the Department of Wildlife, you never know, people. Humans are an odd group, folks, if you haven't figured that out yet. So know that there's different things that they can change as far as the assistive animals and what it is. Goats, ducks, rabbits, God only knows. Monkeys, I've heard it all. Hold on, we got another question. Can you demand before move-in for documentation on a service animal? If they notify you that it's a service animal, a lot of times they won't tell you until after they move in, and I'm being realistic. If they haven't told you anything, how do you demand the information? So it makes it extremely challenging and difficult for us. Hold on, Karen, I got you. What about policies restricting certain breeds of dogs? Do we still have to permit breeds outside of the existing policy? Here's how that works. The breed restrictions are in place because of the owner's insurance, okay? Pit bulls, Akitas, Rottweilers, there's like 17 different dogs on there. They even put Great Danes on there, okay? Huskies, I mean, the list goes on and on. There's like 17 different dogs on there. That has to do with the owner's insurance. It doesn't necessarily have to do with that tenant. And when they have, we can't make them, if it's an emotional support animal, therapy animal, anything like that, we can't force them to do anything. We can't get extra money, extra deposit. We can't charge them anything. We can't make them get an insurance policy. I need you to look at that, not as an animal, but as a wheelchair. Would we ask somebody with a wheelchair to fill out special rules or demand that they give us a statement before they move in? No. So when it comes to emotional support animals, therapy animals, any of those kind of animals, I need you to start thinking about it as a wheelchair. Because if you think about it as a wheelchair, you'll most likely answer your own questions, okay? Can I charge an extra deposit? No, I can't do it with somebody with a wheelchair. How could I do it for the emotional support animal? Remember that when it comes to animals, emotional support therapy, all of that, it's only this much fair housing. They want to make sure you're not discriminating, but it's this much ADA law. It falls under the American Disabilities Act, which has much bigger teeth than fair housing. Fair housing just wants to make sure that you didn't discriminate. Then when you're dealing with the ADA, okay? So keep that in mind. They have really big teeth and you don't want to go poking around at that bear, okay? So think of those animals as wheelchairs. Can we charge an extra deposit? No. Can we charge additional rent? Absolutely not. For somebody in a wheelchair? No, not a chance. Can we do this? Can we do that? Can we make them get a note from their doctor? No, no, and no. So it makes it a little bit more challenging, but kind of helps put it in perspective when you start thinking of it as a wheelchair. It's just not worth the risk. Sometimes they tell us up front before they move in because they don't want to pay pet rent. Then ask them at that time if they have the documentation for that animal. I don't say the doctor's note, I just say the documentation. And let's be honest, you guys, we can go on Amazon and for 12 bucks, I can print out an ID card with my dog's picture on it saying that it's an emotional support animal. It's got an airline thing, it's got a fair housing thing. I mean, chances are most people that are utilizing that, I would say quite a few of them aren't being completely honest. They may have gotten that certificate off of Amazon, but the reality is it's not a bear I want to go poke at. When that animal causes a problem at the community, just like a caregiver that's not a resident, we can ask them to exchange that animal for a different animal that isn't a nuisance at the property, that isn't lunging, biking, striking, barking, maiming people. I mean, whatever it is that the issue is with that particular animal, we can address it as becoming a nuisance, but that's something you definitely want to do with your legal counsel standing behind you so you don't misspeak, okay? Because that one can hurt a lot. But example, you have a dog on the property, it's an emotional support animal, it bites someone else, that's a problem. You need to address that right away with your legal counsel immediately. Chances are that person won't be living there much longer because that's a liability that this animal now caused, okay? But there are things you can do. You have to wait until it actually happens, unfortunately. So if you have a dog that's in there that's barking all day because they're home alone, that's a nuisance, okay? That could be a problem. That's something you can report. There's things that you can do, maybe not at that particular fact that they can have an animal, but what kind of animal it is. Make sense? Any more questions about that? Okay. Assistive animals, that's a big one. I went through all of that. We're going to talk about desperate impact a little bit. What that does is it can cause problems later down the road. If you make a rule regarding a policy or a practice, it may cause problems down the road, okay? So you need to be careful that what you're doing doesn't cause a desperate impact later down the road and doesn't treat people differently on its face and change that all up for you. Let me look. There's one other thing I want to really talk to you guys about because, and I got to go backwards to get it. I'm sorry. I wanted to talk really quickly on arbitrary factors. A lot of people don't understand what arbitrary factors are. And it is a cause for discrimination here in the state of California. Arbitrary factors are things on a whim. So let's say that the person that's applying to rent your property has tattoos and baggy pants. If you don't rent to them because of those tattoos and the baggy pants, that's an arbitrary factor and it is discriminatory. Okay, you guys got that? So you want to be very careful that you're sticking to your criteria. I know that the apartment association there has example criteria for you. Follow that. They have gone true and true to get you the best information that they could. Don't go changing that up and adding your own verbiage because it makes sense to you. The reason they've written it that way is because that way works, okay? So utilize their criteria. That helps tremendously in setting those rules. But you want to be careful with arbitrary factors. They can bite and they bite hard. Usually, oh, they discriminated against me because of this or because of that. They usually throw arbitrary factors in there, so it is something that we see quite a bit. Not so much recently with all COVID going on, but it is something that we definitely see. Anybody have any questions yet? No? I love it, I love it. As far as violations for desperate impact, you could see a lot of things happen with housing related policies or practices that could have a desperate impact later. Predatory lending, credit scoring overrides, land use and zoning decisions, residency preferences for Section 8 vouchers. I'm going to talk about that right now. I'm sure everybody is aware that we cannot discriminate against Section 8. If they have Section 8, then they must meet our criteria. If they meet our criteria, we have to rent to them. That's how that works. We can't say, I'm sorry, we're not participating in the program. Those days are gone. We are now forced to accept Section 8, just so everybody is fully aware of that. If you weren't already, I hope you are now. Yeah. You want to be careful that you're not refusing to rent to someone based by your mouth, okay? The apartment association, also your credit screening company has something when you run someone's credit to put them in your unit, and that would be your adverse action notice is how you're notifying them that you're denied. You want to stick to that. You don't want to sit there, oh, you're going to be denied. This is not happening. You will not rent from me. You can't do that, okay? They either meet your criteria or they don't. We're starting to see a lot more major corporate companies use third-party screening agents. That way, it limits your liability and exposure. Apparently, you didn't screen them. Somebody else that knew nothing about them made the decision that they met your criteria or they didn't meet your criteria. And that limits your liability and your exposure to a discrimination lawsuit tremendously, okay? just so that you understand. Using those third-party screening companies helps eliminate that whole debacle. So I thought I'd share with you a couple of stories, just so that we're all on the same page and we are all seeing the same thing. Got a phone call once at the law firm from a property manager I'd been working with for quite some time, a regional manager. And she said, "Hey, Patty, you got a second?" And I said, "Yeah, what's up?" She said, "I just got served a lawsuit." And I said, "Oh, I'm so sorry to hear that. What's it for?" And she said, "Discrimination." I said, "Really?" She goes, "Yeah, and I'm still trying to comprehend what's going on here, but there's like 62 defendants, all with dates, times, and witnesses." I'm like, "Whoa, what's going on?" She goes, "Apparently, the on-site manager is having some challenges. Children were playing in the common area with a football, and the maintenance man went out and took the football away from them, telling them that they can't play here. That's a problem. That's discrimination." She went up to some girls that were playing, and I don't know if it was Pokemon or not. Just go with that, because that's what I remember. They were playing Pokemon cards on their front porch after school. About 3 11-year-old girls. One of them was a resident there, and the other 2 were visiting after school. They're out there playing cards. On-site manager went up and told them that they can't loiter here. They're loitering on their front porch. At 11 years old, you don't even know what the word loitering means, okay? They took down their jungle gym system and didn't replace it with anything. They took the tether ball away from them. You want to be really careful what you do and what you say, because not only can they go after the building owner and your management company that you work for, they can come after you personally, okay? So you want to be very, very careful that you treat everyone the same, everyone across the board. Remember it this way: if you do it for one, you have to do it for all. And a lot of times you get it with, "Can you just please waive my late fee? I can't pay it this month. Please, I need your help." If I do it for one of you, I have to do it for all of you, and I don't have that kind of power. So there's little tips and tricks that we can use for the things that we're challenged with the most, as far as keeping it even Steven across the board. If I could put one thing in your head today, it would be actually 2 things in your head. Don't talk in absolutes and don't write in them, okay? You're less likely to get yourself in trouble down the road. Also, remember this: treat everybody the same. If you do for one, you have to do for all. So if what they're asking you to do isn't feasible for you to do for everybody else, then you probably don't want to do it, okay? And you can use that as an excuse. "I can't treat you any differently than I treat everyone else, or it could be considered discrimination. And I'm sorry, it's not worth my job." So there are little things that you can do and say to them to help them realize that you can't just do something just to help them. You have to do it for everybody. You treat one the same way as you treat everyone else, okay? Everybody got that? You also want to make sure that your rents are pretty consistent. You don't have someone that's paying $300 in the same unit that's paying $2,400 for an identical unit in the same building. This could be considered discrimination. Okay, so you want to be careful that you're not discriminating, you're not segregating, and try the little trick with the absolutes. It helps tremendously, I promise. It even helps when you're writing something so that it doesn't sound threatening, okay? Because we don't want to sound threatening to anybody. And we want our attorneys to sound threatening, not us. Anybody have any questions? Did everybody learn something? I can go a little bit further into examples of discriminatory language just so that you guys have those. Advertising whites only or no children allowed. These are obvious expressions of discriminatory language. Common violations are adult community, Can't say that. You can say senior community, but not adult community, okay? Must be gainfully employed to apply. That's discrimination against financial status. What if they're not employed? What if they're on disability? Okay. Must be a US citizen to apply. Can't do that either. Student or senior discounts. Can't do that either. Remember, we have to treat everyone the same. Singles only. Remember, we want one person's maximum occupancy, not single person. Don't use the word single, okay? It's bad any way you say it. That they must speak and understand English, that's also discrimination. And please be aware of visual discrimination, okay? This is a thing, trust me. And I always thought, what is visual discrimination? Is that how you look at someone when they're talking to you? Because that could be discriminatory depending on if they've had their coffee, if they're cranky all day, you know? I mean, it could be. But what they're talking about doesn't even involve meeting us or seeing us. We could be guilty of discrimination by our advertising. And that's what they're talking about, visual discrimination. So when you're advertising a community, you want to make sure that you don't use photographs of people. Because if you do, and I'm not talking about your employees, like sometimes you have a picture, this is the on-site manager. Okay, you're identifying that that's the manager. That's not discriminatory, okay? However, if you have pictures of your common area and kids playing, as an example, or a couple walking through the common area, if you just show the couple walking and you don't show a single person, that could be considered discriminatory. You could be steering that that's only for couples and not children, because there's no children in your advertising, and you didn't touch every ethnicity and every ethnic background. You didn't include people with wheelchairs or disabilities in your advertising. Do you guys want to know how to fix all of this without having to stress over it? Don't put pictures of people in your advertisement. It makes it real simple, okay? Because if you put pictures of people in your advertising, you have to include everything. Just wheelchairs, handicaps, disabilities, every ethnic background, families, non-families, single people. And then you have to get into the whole LGBTQ thing and make sure. Just don't put pictures of people in your advertising and eliminate that problem altogether. If you want to make comments that it's near a bike riding path, put a picture of a bicycle with some shoes next to it. Don't put a person on the bike. Then you're not discriminating with visual discrimination. Okay? Does that make sense to everybody? Don't use pictures of people in your advertisement. You want to advertise about the bike path being nearby, then put a picture of a bicycle with no person on it. It does work best, I promise. Anybody have anything that they want to talk about or address? Nothing? Lorna, is there anything else you want me to address or talk about? Lorna, where'd you go? Not there. Okay, so remember this, you guys. Don't advertise anything about service animals, emotional support animals. If you're a no pet property, then state that you're no pets. If they show up with that dog, know that they're gonna probably most likely come with a note too. And I get your point that they'll tell you because they don't want to pay the pet fee that they have an emotional support animal or a therapy animal. Tell them that you need the documentation for that. There's nothing wrong with asking for the documentation for their assistive animal, therapy animal, emotional support animal, okay? A lot of people will tell you, oh, I have a guide dog. They're not blind. Guide dogs help blind people. So you can almost tell right away when they're fishing for being deceitful, when they are, okay? I get a lot of times, I have an emotional support pet. well, wait, is it an animal or is it a pet? Because now you're confusing me. So a lot of times they speak wrong. A lot of times they just tell on themselves. Oh, well, I printed that out on Amazon so I could have my dog here. It doesn't work that way, unfortunately. There is some third-party screening companies now that offer pet screening where they'll handle all that for you. Also, again, limits your liability and exposure. Puts it more on that company rather than on you, so that can be helpful as well. And I'm sure that the apartment association can help you with that resources. I also know that they have the request for reasonable accommodations and for reasonable modifications in their database. If somebody has an emotional support animal and it's a no pet building, they need to fill out the request for reasonable accommodations so that you can prove, if challenged by fair housing, why you changed the rules for that person and not for everybody else. Very important that you treat everybody the same, equal across the board. And remember, you don't place tenants in units. You place tenants as units become available. Okay? Anybody have any questions? We're good? Lorna, are you still with us?
I'm there. I'm here.
Is there anything that you want me to touch on?
No. I just wanted you to perform the class, to teach the class and go over fair housing and answer any questions that the attendees had.
Okay, I think we've done all of that. I just didn't know if there was something else that you guys saw as challenging right now. I will go off of this and talk just briefly about what's going on with us and moratoriums and the whole COVID pandemic. Be careful, you guys. We're starting to see laws being put in place, which is paving the way to get us out of here. In other words, I see light at the end of the tunnel, okay? For them to put in the new AB 3088 tells me that they are gearing up for opening us back up, okay? Because they're putting the rules in place that we have to follow going forward. I'm sure everybody's aware that we no longer use a 3-day notice for non-payment of rent, at least until February of 2021. It is now a 15-day notice, which we can't count weekends and holidays on, so that's more like a 20, 25-day notice, depending on when that notice is served. So we're starting to see things move in order, and they're starting to come together as far as them reopening the state and as that goes. In the meantime, let me remind you of one thing. Although everything's starting to open up, everybody's still a little leery about raising rents, terminating tenancy. It's definitely something you're going to want to talk to your legal counsel about. I do call fair housing probably once a week just to check on various things and scenarios for clients and that sort of thing. Please take note. We have not heard from the Department of Fair Housing yet of what is a reasonable amount of time to terminate tenancy or increase rents after a global pandemic and it not be considered retaliatory. So could they throw that at us? Yes, they could. They haven't yet, but again, we're not completely open yet. So just something else for you guys to think about is fair housing hasn't said what we can and can't do yet, what's reasonable, what's not reasonable. So just think as things start to come into play, that could be something that we hear that changes our outlook on everything. In the meantime, I suggest you to err on the side of caution. Remember, there is no case law regarding COVID-19. This has never happened before. We don't want to be made an example out of through a lawsuit that everybody else follows because we did something wrong, okay? Err on the side of caution, always. There's no rules for this. I saw one more question come through. If they have not said COVID-related issues for non-payment of rent, they were always late on rent before March of 2020, can we serve a 3-day to pay rent or quit? Absolutely not. Nope. 3-day notices are gone until at least February of 2021. And by then, and I'll be very honest with you, they'll probably change the law. Here's what happened. For a couple of years now, we've been fighting because they've been trying to take away our 3-day notice to pay rent or quit and change it to a 15-day notice. They use this COVID opportunity to do that. So if your tenant says they're affected by COVID, the new AB 3088 could take effect there and play that out. But a 3-day notice to pay rent or quit is no longer valid right now. It is not able to be used, enforced, and could it be considered harassment? Possibly, because you're not following the law. The law changed. Read AB 3088. If you have somebody that owes rent from September this month all the way until January of 2021, you must use the 15-day notice to pay rent or quit. And also serve them with that declaration stating if they were affected by COVID and how. So definitely something to know, but 3-day notices are gone, okay? Anybody that pre-filed a case with in the last 6 months so that they were in line once the courts opened and you have a 3-day there, that case is probably bad. I'd contact your legal counsel because they now require a 15-day notice and for it to completely expire, meaning no weekends, no holidays, court days only. I hope that answered your question. I got you, I know, but they're changing the rules on us. And don't be surprised if this actually changes going forward, okay? And what I mean by that is don't be surprised if you start telling people 10 years from now how you used to be able to serve a 3-day notice and now it's a 15-day notice. Because I'll be honest, I most likely see that they've been trying to do it for 2 years, for the last 2 years, and we beat it, we've beat it, we've beat it, and now here we are having to deal with it. So yeah, 3-day notices, at least until February 1st, are null and void in the state for non-payment of rent on residential dwellings. Okay? Be careful. As these rules come out, they're new to all of us. We're trying to come up with processes and procedures to help us get through these times. It's not a rush. We've been waiting 5-6 months for our rent all this time anyway. It's not a race to see who can get in eviction court the fastest, okay? We want to, again, err on the side of caution because this has never happened before. Don't be surprised when we see quite a bit of lawsuits come out in regards to it, because that's usually what happens. Then we have case law and then we know which way to follow the rules. So don't be a part of the trial and error or trial by fire because we don't want that. I don't like to get sued. I don't know about you, but I don't like it. I'd rather be extremely confident in what I'm telling my client and let them know exactly the process and the procedure and how it's to be played out. And right now, we're just starting to see that come in with AB 3088. Fun, right? And then remember, please, if you have someone that is currently delinquent, you do need to notify them of the Tenant Protection Act and that disclosure by the end of this month. So trigger, if you have somebody that's behind, definitely check with the apartment association on their new packet regarding the 15-day notices, the declaration, and also the disclosure regarding the Tenant Protection Act. If nobody has anything else, I will end this for today. Big sigh. I got a big sigh. I'm sorry, I know. Fair housing isn't fair, it's equal.
Thank you very much,
Thank
Patty.
you.
I don't know if everyone that's on today attended our AB 3088 webinar we had on Monday, but we are working on scheduling another free one this month.
Oh,
And
most definitely.
forms, and so they're in the 400 section on the website. So when you log in the forms, scroll down to the 400s and you'll see it'll say new form, new form, new form after it. I don't have the exact numbers, but it's in the 400 series. And I want to thank everyone for attending today. Thank you again, Patty.
Thank you for having me.
You're welcome. I hope everyone has a good day. And if you guys, as you know, if you have operational questions, you have the number to the association, give us a call and we'll get you in contact with the counselor to answer your questions, okay? All right, thank you, everyone.
Have a great day, you guys.
Thank you, bye-bye.
Bye.